This case originates in the Southern District of California, which is where I practice. It deals with illegal searches, denied suppression motions, and a 30-year custodial sentence in prison. The officers arrive at a residence looking for someone else, but they encounter Travis Job, who's standing outside of his house. He appears to be nervous, and it looks like he has a lot of items in his pockets, so the officers decide to frisk him. They find a glass pipe, over $1,400 in cash, and a set of car keys. Now one of the officers takes the key, pushes the unlock button, and it seems that the car is parked in the driveway, so they search the car. Inside the vehicle, they find drugs, particularly meth. At some point, the officers also realize that Travis Job is on probation, so he has a Fourth Amendment waiver, meaning that the officers can search him at any time and at any place without a warrant. But the question here is, could they do that? Travis Job is ultimately charged with a meth conspiracy. He challenges the 2 searches that were conducted on him and his vehicle, and those are ultimately denied at the district court level. He then goes to trial and loses and receives a 30-year sentence. Mr. Job appeals his conviction and says that the searches were illegal. Now the government relies on a 2013 case, United States versus King, which states that officers are permitted to search a person without a warrant if he's on the Fourth Amendment waiver. Now, I've posted about a Fourth Amendment waiver and being on probation generally a couple of weeks ago. I will link that video at the end of this one so you can watch it. But in this situation, the justification for the search fails for 2 reasons. Number 1, the officers did not know that Mr. Job was in fact on probation and had the Fourth Amendment waiver. They only found that out after they conducted the searches. And the second reason it fails is because it only works on individuals who are on probation for a violent felony. And in this situation, Mr. Job was on probation for a drug offense, not a violent felony. Once the court decided that the officers were not justified in searching Mr. Job under the Fourth Amendment waiver, the government came up with a number of additional arguments to justify the searches. In terms of searching the person or Mr. Job, the government states that there's 2 ideas or 2 reasons they could have done it. Number 1, under a Terry frisk, and number 2, under a protective sweep. Again, both of those ideas I've discussed before in previous videos, so I encourage you to watch those. Under Terry versus Ohio, a 1968 Supreme Court case, the Supreme Court has stated that when the officer is encountering a person that they reasonably believe is doing something criminal, and if they think that the person is armed and dangerous, they may frisk the person on the outside of their clothing. Now, in this situation, the only thing that the officers knew about Mr. Job is that he was standing outside of the house where the officers were trying to find somebody else. He appeared nervous, and he had large items in his pockets. Nothing about those ideas sounds like somebody is committing a crime. And additionally, there's nothing about him that seems dangerous other than the fact that he's nervous. So the court in this case says that no, Terry versus Ohio does not apply to this search. The protective sweep argument under Maryland versus Bowie, a 1990 case, fails as well. A protective sweep is generally a quick cursory search incident to an arrest. When the officers don't feel safe and they want to see if there's other people on the premises, they can search those premises by simply looking around for other people. In this situation, the officers looked inside Mr. Job's pockets. You can't possibly hide another person in your pocket, so the protective sweep idea does not work. Having said that all the different arguments fail, the search of Mr. Job as a person was in fact unconstitutional. When it comes to Mr. Job's vehicle, we already know that the Fourth Amendment waiver does not apply. So the only thing that the government argues here is the automobile exception. Under this exception, the officers may conduct a warrantless search if there's probable cause to believe that there's items on the premises or inside the vehicle that are tied to criminal activity. In this situation, the officers say that once they found that pipe in the pocket, they had probable cause to believe that there were probably drugs inside the car. Now, the court disagrees. The court simply states that once they found out that the search of a person was illegal, that means they would have never found that pipe. So there was no probable cause to believe anything was inside the vehicle. So the court says the search of the vehicle was in fact unconstitutional. If you enjoyed this video, please click like, subscribe, and hit that bell notification button so next time I post, you'll be first to know.